A lot of people write to me and say, Mr. Noble, do a video about setting up a trust before you get married to try to protect your assets in the event of divorce. I'm going to tell you about a case that just came down in Massachusetts. It was Jones versus Jones. It was decided September 6, 2023, and this is a case of a trust, a separate trust that the court brought into the marital estate, even though the beneficiary of the trust, in this case the wife, never received any money from the trust. It was just an expectancy. But this trust for over $1 million came into the marital estate at divorce. Stay tuned. You'll learn why a prenup is really your best first line defense to protect assets, and a trust can be pierced. Hey everybody, welcome. In case you're new here, I'm Jonathan Noble, divorce and family law attorney, licensed in Pennsylvania and New Jersey. I get a lot of questions from my audience about setting up a trust in an attempt to shield their assets in the event of divorce. And I want to talk about a case that was recently decided in Massachusetts. Dylan Jones v. Juliana Jones. This is a divorce and equitable distribution case. It's fascinating. I'm going to give you a very short synopsis of the fact pattern in the case and why you ought to think about this. Couple were married in Michigan in 1998, and then in 2017, they filed for divorce in Massachusetts, all right? So no prenup. But during the course of that almost 20-year marriage, that 19-year marriage, the wife's mother set up a trust and was very generous to the couple and their children. So there's a trust set up. The wife's a beneficiary. She hadn't taken anything out of the trust, but the wife's mother lavished the couple during the marriage to the point where the wife's mother set up a limited liability company that paid for their house and allowed the couple to not save any money at all, really, for retirement or college. Basically, the wife's mother was very, very generous to them, which is a good thing. But the wife's mother set up a trust worth over $1 million that was going to go to the wife eventually. The wife was a beneficiary. So when they were getting divorced, the wife and wife's attorney, I'm assuming, said, that $1 million plus trust that my mother set up for me doesn't come into the marital estate because I haven't received it yet. It's just an expectancy. I don't have the money. I don't have control over the money. It's going to be doled out to me per the terms of the trust. It can't come in. And the trial court disagreed. They said no. The fact is that your mother's generosity outside of the trust was woven into the fabric of the marriage. And that $1 million plus of the trust that you're eventually going to get, because the trust is set up that way, she's going to get it eventually. But that money is coming into the marital estate when we divide the marital estate. So she filed an appeal. And she lost on appeal because the appellate court agreed with the trial court. And the appellate court says no. The wife's mother made a variety of financial gifts and contributions throughout the years, including but not limited to contributions to settling the trust, gifting substantial funds that were deposited into a CD for the wife, granting wife 99% interest in a limited liability company that holds title to the marital home, and 1/3 interest in real estate located in Michigan. The wife's mother played a significant role in shaping the marital lifestyle and financial expectations. The wife's mother, the appellate court goes on to say, showered the family with gifts, whether monetary or experiential. So she's paying for trips, she's paying for gifts, showered the family with gifts. The wife's mother gave the couple a lifestyle that they could never afford on their own. So, even though the funds were completely segregated in the trust, they came into the marital estate. Looking back as the Monday morning quarterback, as we sometimes are on this channel, what could wife's mother have done? Insisted that her daughter get a prenuptial agreement before they got married that specifically excluded any funds that were given to the couple as a gift and any funds that would be put in a trust for the daughter. So here's the moral of the story. A trust is not your first line of defense to protect your assets, whether they be an expectancy or a gift. That prenup is going to be your first line of defense. Now, she could have set up the trust a different way, but she needed that prenup in order to really shield that $1 million+ from coming into equitable distribution. Let that be a lesson to everybody out there. A trust isn't going to do it. I don't care where you set it up. Eventually, a good lawyer is going to make a really good argument to pierce that trust and put those assets into the marital estate. Prenup's a lot tougher to pierce. Now, with that being said, prenuptial agreement laws vary widely from jurisdiction to jurisdiction. If you watch my channel, you know I've interviewed other lawyers from all different jurisdictions, but especially if you're north of the border in Canada, judges routinely have the power to modify or set them aside, whereas in many states in the United States, including Pennsylvania, they're treated like a contract. As long as there's no fraud or duress, that they are what they are. So get local legal counsel and know what your rights are regarding a prenup. There's no national or federal prenuptial agreement law. So get the mercy of state law. Get a prenup. If you don't, your default prenup is state law. So everybody has one, whether you write your own, which is highly preferred and recommended, or you're at the mercy of state law. Massachusetts case, you can look it up, Jones versus Jones. They filed for divorce in 2017. It's 2023. I'm making this video. This divorce was litigated 6 years. 6 years. Wow. Let that be a lesson to you. Get that prenup. Share this with somebody walking around blind. How could they have avoided this? Don't get married. Then you don't have to worry about going through the courts for equitable distribution and divorce. But people watching 2 minutes of that Hallmark channel, and that's what they do. Be careful out there.